Well, I'm pleased to stand up and debate this bill and present the position of the Official Opposition New Democratic Party of Canada on Bill C-31. I think improperly and inaccurately named Protecting Canada's Immigration System Act, because I think that this bill does damage to Canada's immigration system legally, socially, morally, and internationally. First, I want to talk about the omnibus nature of this bill, which I think is, just from a structural point of view, something that is a disturbing feature of this Conservative government. We saw already, Canadians saw in this Parliament, this government take 9 separate pieces of serious and complex crime legislation and put them into one omnibus bill, and then put that before parliamentarians to discuss and debate. And now we see the minister take 2 separate major pieces of legislation, as well as another serious issue, which is that of biometrics, and combine those into one bill. Now, I want to, for Canadians who may be watching this, explain a little bit about what those bills are. The minister has, introduced by this bill, taken Bill C-11, which was a bill that was introduced in the last Parliament, debated, went through committee, was amended, and was passed in this very House. That bill, C-11, then went to the Senate and went through all 3 readings in committee and was passed there. And that bill actually received royal assent. That's right. Bill C-11 has actually been passed by the Parliament of Canada and was waiting to be implemented this June. The minister has stopped that bill from being implemented this June. And I will tell you a little bit more about what the minister had to say about that bill in a few moments. And that bill was geared towards reforming Canada's refugee system. In fact, I'll quote now what the minister said in June 2010 about that bill. He said, we have in good faith agreed to significant amendments that reflect the opposition's input, resulting in a stronger piece of legislation that is a monumental achievement for all involved. These amendments, I am happy to say, create a reform package that is both faster and fairer than the bill as it was originally tabled. That was the Minister of Immigration's comments on Tuesday, June 15, 2010. The minister stands today before us, to Canadians, and he has taken the original bill that he had tabled in the previous Parliament before those amendments that made it fair and faster. He's thrown the amendments in the garbage and reintroduced the original bill. The very bill that he said was inferior to the amendments that were made by all parties in this House. The minister has, I think not unsurprisingly, neglected to explain that. In addition, this Parliament, one of the first bills that the Conservatives introduced in this Parliament was Bill C-4. Again, inaccurately and I think unconscionably titled a bill concerning human smuggling, C-4. The government introduced C-4, and that bill has been going through debate in this place. And the minister's taken that bill and put that into this current C-31. There's no explanation for why he would take a bill that has already been introduced and moving through the system, slow it down, and put it back into this legislative process, basically putting us behind where we would have been. I have a theory as to why that may be the case, Madam Speaker, and that's this. Bill C-4 has been roundly condemned by virtually every single group and stakeholder involved in the immigration system in this country, from lawyers, from refugee groups, from churches, from groups from immigrant settlement services across the board. I can't name any groups that have sent any message that they support Bill C-4. And third, the government has taken another issue, biometrics, and put that into the bill. And what's puzzling about that, Madam Speaker, is that just approximately 30 days ago, we commenced a study in the Standing Committee on Immigration Citizenship on biometrics. We have had a handful of meetings and are in the middle of our study of biometrics when the government has introduced legislative steps on the very thing that we're supposed to be studying. I wonder what that says about this government's view of the work of standing committees and the experts and witnesses who appear before our committee when they actually come to a conclusion before we've heard all the evidence. Now, I want to talk a little bit about the substance of these bills. Let's talk about C-4. C-4 was a bill that this government hastily drafted when we Canadians witnessed the spectre of 2 boats come to the shores of British Columbia carrying some of the most damaged, some of the most wounded people on earth, people fleeing, as the minister has rightfully pointed out, one of the worst civil wars in the world in Sri Lanka. Now, there were some 550 people on those boats. And never one to pass up a good photo op. The Minister of Immigration and Minister of Safety were there doing news conferences outside, accusing the people on those boats of being bogus and accusing them of harboring terrorists. They said that publicly, and accusing them of queue jumping. Now, what anybody who's familiar with the immigration system knows, up to now, is that there is no queue jumping. It is absolutely a normative part of our refugee system for people to make their way to a country by regular means and make a refugee claim, and the Minister of Immigration knows that. There is no queue that's being jumped, and the Minister of Immigration actually went into immigrant communities who are suffering long delays in their applications for permanent residency to sponsor their parents, and prey on their frustration at his government's inability to deal with that backlog and wait time, and try to foster resentment from those immigrants towards these refugees. Madam Speaker, we always want to be careful about our analogies, but if there were Jews fleeing Nazi Germany during World War II and they made their way into a neighboring country through the dark of night, they didn't come with a visa, they didn't come through any UNHCR process, there wasn't one at the time, there was no international process. They just made their way to safety. Those people are not bogus, those people are not jumping any queue, those people were escaping for their lives. And that's what people do, and that's what those people were doing on those boats. Number two, to make the claim that those people were terrorists, before there was any adjudication, has turned out is as incendiary and inflammatory as it is wrong. To this day, of 540 people, there are not any that have been deemed to be terrorists. And if there are any people that have any kind of question about their origin, it's less than a handful. Less than a handful with any kind of question out of 550 people. Now, Madam Speaker, what does C4 do? It allows the minister to concentrate, he wants the power, the Minister of Immigration, to designate people as irregular arrivals. And under the Act, it just says a group. It doesn't define how many. We presume it's 2 or more. What happens to those people? Those people can be detained for up to a year without review. Now, let's talk about the legality of that. The identical provision has gone to the Supreme Court of Canada in the security certificate cases, and it's been deemed unconstitutional. Yet this government puts it right back into this bill. Moreover, now the minister says, well, they can come out if they're deemed to be refugees. Well, that's true, but that assumes that we have a refugee determination system that will make that determination in under a year. If they don't, they're stuck in detention for up to a year. Even if those people are deemed to be bona fide refugees, this part of the bill still would prevent those people from being able to make a permanent resident application for 5 years or sponsor their family for 5 years, which I will say right now is a violation of the UN Convention on Refugees and a violation of the UN Convention on the Rights of the Child. And I'll explain for the minister exactly why that's the case, because I put this question to him and he avoided answering the question. That's because of this. The UN Convention on Refugees says signatories, which Canada is, are not to put penalties on people who arrive at our shores by irregular means. People that are deemed to be refugees, if they are then prevented from sponsoring their families for 5 years, or they're prohibited from making a permanent resident application for 5 years, are absolutely being penalized because of their irregular entry. Now, the minister said, well, they could be, if they make a successful refugee claim, they'll be let out within a year. That's true. But what about the 5-year bans? The minister refuses to answer that. And that is a differential treatment of someone who comes through any other process, and it's a violation of the UN Convention on Refugees. In terms of the rights of the child, Madam Speaker, you could have a person, and there were people on those 2 boats, the Ocean Lady and the Sun Sea, who came to Canada's shores, who are children traveling unaccompanied. So if you have the UN Convention on the Rights of the Child obligates signatories, of which Canada is one again, to put the best interests of the child first and foremost in our determinations, and that includes in the immigration system. If you have a 14-year-old or a 12-year-old child who comes to this country and they're deemed by this minister to be an irregular arrival, they will be prohibited from sponsoring their parents for 5 years. That is not in the best interest of that child. I say there's a violation there. Lawyers across this country, from the Canadian Bar Association to the Canadian Association of Refugee Lawyers, have all said that the detention without review process will be attacked by the Charter, is a violation of the Charter 3 different ways. And that this Act is going to go to the Supreme Court of Canada, mark my words.